All right, now we're joined by David Mann, who's running for election to the Court of Appeals, Division 1. So go ahead with a 2-minute introduction.
Thank you. Hello again, Judge David Mann. I was appointed by Governor Inslee to fill a vacancy on Division 1 of the Court of Appeals in July. I began serving in August. We've had an active calendar since then. Under the Constitution, I'm required to run again on the November ballot to retain the seat to fill a vacancy, which will be another 3 years. At this point, I do not have an opponent. I hope to keep it that way, and I'm working very hard to keep it that way. What I'd like to do is give you a little bit about myself and a little bit about the court so that between the two you'll understand why I believe I'm an important addition and an important member to the court. Myself, I was born East Bay, blue-collar upbringing. Dad drove for the Teamsters. He was lucky enough to give me a job as a teacher warehousing. So I worked there my last couple of years of high school, and between that and scholarships, I was able to attend the University of California. I loved the outdoors, so I became a geologist. But I also loved math and became a physicist. So combined the two, became a geophysicist. That took me to Houston, last place you wanted. We made it 4 years and skedaddled back up here, where I earned my law degree at Lewis & Clark in Portland, and then I spent 26 years here in Seattle representing neighborhood groups, citizen groups, environmental groups, families, individuals on land use and environmental matters. Mostly communities, mostly opposition type information, with a strong proponent of the Growth Management Act. I represented the underdogs, and that I did it slightly below cost all the way through my career. And that's why I bring something important to this court. I didn't come out of the prosecutor's office. I didn't come out of a large law firm. What I bring to the court is the understanding of how to represent people and listen to people that are coming from a little more narrow background. Our court is the last stop for most people. Most cases don't go to the Supreme Court. They come to us. Every case out of Superior Court comes to us. So we're the last stop. And I believe I fill an important role. I'd like to maintain it.
Great, thank you. So now we have our 4 prepared questions that we're asking all candidates for Court of Appeals. And they're actually right in front of you if you want to turn it over and read along as we read them aloud. And Sophia, will you start with number 1?
What barriers to access are there at the Court of Appeals for underrepresented litigants, people with disabilities, and other vulnerable populations? And what steps have you taken to promote access to justice?
Well, in a Court of Appeals, one of the issues is most people that come to us are represented by counsel. Now, in the criminal matter, that's often appointed counsel, and there are laws that are appointed counsels. In the civil, that does not apply. There generally are no appointed counsels. There are nonprofits that do represent on the civil side, but that's just the cost issue of having adequate legal representation is the largest impediment to access. And even on the defense side, we have some amazing public appellate defenders in this state, really good, but they're stretched to the limit. I'll often get an opening brief from the appellant, a response from the state, and I won't get a reply brief, which really is disappointing. It hurts, but I know what the reason. The reason is budget and time and expense. Same thing happens in the civil. We'll see often a nonprofit step in to represent, but we won't have enough. There won't be enough in that budget to continue and see the reply. So it's access, it's money and access is the largest thing we can do. The other thing we can do is we can cut costs of appeals, and that's going to mean getting the cost of the records. We get huge records. Everything that comes out of those trial courts, exhibits, testimony, transcripts, is all paper. And a lot of that comes to us in just boxes and boxes, and the appellant is required to pay that cost to get that transmitted. And until we get our system electronic. So one of the first things I've done is jump on with our court to help speed up our electronic access, so that all files that come out of trial courts, all of them are turned into electronic format, and they can come to us in electronic format at a significantly reduced cost, and that's saving the cost of appeals.
David?
What state or federal Supreme Court decisions do you disagree with the most?
Citizen United, absolutely. But maybe that's getting too political, but for obvious reasons, I think that it's a huge Welsh democratic system. State Supreme Court? I can put a finger on one I really disagree with on the Supreme Court. I mean, there are decisions that are bad, but I mean, I can pick on a couple of the environmental decisions that I think went the wrong way. But then I would be picking on those because I was an advocate at the time. And so maybe I just disagreed on that, but it'd be hard pressed for me to pick on the Supreme Court opinion.
Thank you. All right, Jason, number 3.
Do you support the current system of electing judges, or do you support some other system such as appointments or an appointment petition election hybrid? And if the election continues, what reforms of the current campaign finance rules would you support?
I'd probably personally support the appointment retention election process, which is exactly what I've gone through, and which is actually fairly typical with the Court of Appeals and often with our Superior Court. This year we had a lot of Superior Court openings that were uncontested elections for last year. Court of Appeals, because of the nature of the work and the workload and the ability and desire to want to read and sit essentially in a cubicle and read thousands of pages and research and write. I think there's a reason to have a merit review, and so I would support the idea of the appointment. But again, I do strongly support at this point the election. So I think once appointed, the candidate should have to run for position. We are elected. We make hard decisions. I think anybody that's going to stand in judgment of a dependency or termination, hardest things we do, taking away our parental rights. I think that's the hardest issue we deal with. I think we owe it to be elected before we make those decisions. So I think that and in terms of campaign finance reform, I wish we could. We had a bad example last year with the Supreme Court, where we had PAC money coming in at large levels on the Supreme Court candidates. I think it's very disappointing. I don't know how to fix it, but it's a very disappointing process. And it was rare that we actually had that, but we did last year. So far, we haven't seen that at the Court of Appeals level.
Great. Sherry, number 4.
Please tell us about the types of community service you do and the professional and public organizations you've been involved with.
Well, this is a fun one because I'm in the middle of a transition period, 7 months on the court. Historically, I was very involved with primarily the environmental community. I've been board members of Washington Environmental Council, FutureWise, Washington Toxics Coalition, Conservation Northwest, over the years. I've been very active in those roles, serving on the executive, on almost all of them, serving as president of several of them. But with the transition to the court, all that needed to stop. And so all of those activities have gone away. And so at this point, where I have my name in to start working on the access to justice portion of the court, just subcommittees within the court process, just to get the appointment going and start working on that. And the second thing is working on is trying to get more involved with recruiting potential future judges. We're going to see a major overturn in Division 1. This court I was served on, we have 10 judges. We hear cases from King County, Snohomish, Skagit, Whatcom, and San Juan counties, the largest of the 3 divisions. I'm the youngster on the court, and we have at least 3 to 5 judges that will likely step aside in the next 5 years. So recruiting people to fill out the court, I think, is going to be critical. And for me, getting out there and disabusing some people of some concepts that they might think they shouldn't run. For example, I was always questioned, I don't have a criminal background. How can I possibly do this job? That's not the problem. In fact, it's often just the opposite. Without having somebody that has a strong civil background, which the law can be as or more complicated. We need to get out there. We need to get out to a more diverse crowd than we have currently on our court and reach out. That's really where I want to focus.
Right, so now we'll open up to follow-up questions. These are 1-minute answers, and we'll start with Summer.
So I got your answer for the vulnerable populations and really targeting, the appellate public defenders, sorry, not federal, public defenders is a really valid point, especially because I see that as a positive right that we have in our Constitution, both state and federal, of a right to counsel. I also see that there's other positive rights that are under attack often right now, as positive rights are a hard thing for courts to defend because they do require money, which is a legislative issue. And so just wanted to get your thoughts on positive rights and how can the courts help step in and support and defend positive rights in our Constitution?
Well, we have to the right. We have to be willing to write about it. We have to be willing to write the decisions. Even if we aren't the funders, we have to be willing to write the decisions to raise the issue so that we can then use that legislature. The courts, the administrative office of the courts, which oversees all the, particularly the appellate courts, the 3 appellate courts and the Supreme Court, they actually do have a lobby team, and they are down there actively working for funding, particularly for the Office of Public Defense and getting money out there. So working with that, but you also have to be willing to write the decisions. I have a case currently that has what we call a statement of additional grounds, which an inmate is always allowed to submit. It came in Spanish. There's no budget to translate. So I'm going to fly translate it. I'm just going to pay to have it translated, and then I'm going to write something about it, about why there's no budget to translate this. But we have to be willing to write about it and raise the matter to the attention so that we can then, somebody can then take it to the legislature to fight.
Additional questions? Liz?
I'm wondering about your interest specifically in the appeals court. There are a lot of different courts you could have wanted to be appointed to and run for, and you chose appeals, and that kind of fascinates me.
I absolutely love it. I explored it for a long time. I spent time down looking at talking to judges at the trial court level, talking to the presiding judge at the trial court level, who I tried 3 or 4 cases in front of him, trusted for judgment. I also spent time talking to all the appellate judges and other divisions. And I'd spent time in the appellate court, quite a few cases there. So I knew what I was getting into, and it's not for everybody because we are isolated. Within our own little world, we don't see the public very much. Unlike the trial judge who sees the public every day, all day long. I don't. We have 21 days of argument where I hear lawyers, and those are 2 hours for 21 days. But I like the ability to just sit down, get into the facts, get to the bottom of the facts, get to the law, and get to the right answer. And it's just so challenging and so enjoyable to spend the time to get to the right answer. And I just love it.
Great. Clinton?
I'd just like to ask you to follow up on your remark about translators, because it's not 1920 anymore. At least we'd like to think so. And we have a significant population of Hispanic people in this state. And I'm not going out for a party in Casablanca, but I'm shocked that there is no budget for translators for the Court of Appeals. So I please follow.
Let me fill in a little more detail. First of all, recognize there is a budget and an absolute right to an interpreter while at the trial court level, in whatever language there is. And there's a vast system put together of translators from just about every language in their court certified. It's a pretty detailed process. By the time it gets to the Court of Appeals, generally you're represented by counsel. And generally the counsel has either access to an interpreter, or if you're dealing with somebody that doesn't speak English as their first language, there's access to an interpreter for the attorney. So it's only this one narrow ground where, and it's only in the criminal field, where a criminal defendant has the right to submit an extra statement. Here, my lawyer said all these things to you, but they missed this, and this. It's called statement. And those come in, and that's in that limited area. There is just simply no budget. And so, again, my answer once I learned that that's the problem. I've only seen one so far in 6 months, but I'll write about it and we'll get it translated.
Thank you. David?
In your answer to our first question, you talked about dollar and access and efficiencies and pending costs in the Court of Appeals. And you touched on technology. And I'm just wondering what the current state of the technology is down at the courthouse, and whether it's enhancement or is it modern, does it need updating? What do you think are the technology needs of the court?
It goes court by court on the trial court levels. King County is in pretty good shape in terms of getting everything. Most filings go into King County in electronic format. Almost everything is both taken video and translated, so that's getting more efficient. Still cumbersome things like exhibits don't get scanned as a matter of course, or administrative records, which is something I used to deal a lot with. You do one of these land use cases and they come in with a massive record that doesn't get scanned, and so that ends up being an impediment. Once it gets to us, we're pretty fully set up for anything. I mean, I've got 3 screens and a nice processor. I actually have 2 computers, so I can walk over to stand-up desk and work on one, or work from the 2 or 3 screens on my desk. And I work almost electronically, almost exclusively. But I ran a paper-free office before I came to court. My 2 law clerks are both, they do almost everything electronically. So we're ready once it gets to us. So the impediment is getting it from the superior courts, which is actually the best cost reduction. We get the cost down.
Okay, Sam?
So, and again, I usually look in federal. So right now, in state, administrative records do not have to be electronic. I mean, that seems like a huge issue that, I mean, is that something that the court system could address?
It could address, but a lot of it is, so in the federal system, so if I challenge, let's look at Moria Island, San Gabriel, you're out there. The record was probably 1 million pages, put together by the Corps of Engineers and the various fisheries agencies. It was all on DVDs, it was all hyperlinked, it was amazing. If I'm getting an administrative land use case that comes out of Snohomish County, more likely I'm gonna get a box of loose paper, and that's the administrative record. And that's it. It's not scanned, it's rarely indexed. It just comes in as a box of loose leaf paper. That is something that needs to be addressed at county by county level to get the superior courts up to speed. And the court, the administrative office of the courts is pushing that down and trying to push the technology down and get these things scanned right away. But we are far behind the federal courts. And again, that's cost. Because somebody's paying to send those boxes of paper to us.
We have time for a couple more questions. Going once, going twice. I'll ask one we often ask judges. Who is your judicial hero? Either a justice of the Supreme Court, federal or state, or Superior Court, yourself, anybody who's been a judge.
I have to do this the multi-part because there's federal and there's state. At the federal level, if somebody's going to kick me in the head and I'll say the notorious RBG, because she is, that's what she's done. I also have a personal favorite because I had one trip to the U.S. Supreme Court and Justice Kagan wrote the 81 decision in my favor, so I love her. I didn't have to go, but so those 2 on the U.S. Supreme Court by far. On the state Supreme Court, not that I agree with all of his opinions, but the reason I decided to run for or be appointed to the Court of Appeals was a decision that was written by Justice Stephen Gonzalez 5 years ago now, called State versus St. Collie. And it was a decision dealing with jury bias and the use of peremptory challenges. You know, if you've ever sat on a jury, the lawyers get a chance to just kick 4 people off for any random reason. That's an inherently biased system, and it just asks for abuse. And Justice Gonzalez wrote, I thought, a beautiful concurrence that explained what was wrong with the system, and it just woke me up. And again, I wasn't a criminal lawyer, but that decision woke me up, and I've followed his writing since then.
Last question, Ben.
You said you disagreed with the citizenship decision on the Supreme Court. What can you do to help reverse that decision, and what can we do with your advice to reverse that decision?
I can't do anything to reverse it. I wish I could. It is a federal system by our U.S. Supreme Court, and that's going to take probably a constitutional amendment on the overturn of this court. And I think you already know what that challenge is, and you're already gearing up for that type of challenge. Unfortunately, the court appellate judge here, the state appellate judge, there's not a lot we can do. What we can do is try to do our best to make sure what we're seeing comes to is a just legal outcome. That we're seeing that we can keep the bias out of our courtrooms, we can get access to our courtrooms fair, even, and that's really what we can do, and that's our level. But I have to leave it to the politics and the rest of you to make those changes.
Great. So we're out of time if you want to take 30 seconds for a closing statement.
As you can see, I've been working hard on endorsements. At this point, I've been endorsed by all of the Supreme Court, all the courts of appeals, most King County judges, at least those I've asked so far. I don't expect an opponent, but I want to be ready for one, just in case. At this point, I believe any opponent is going to be somebody that just kind of comes out of the woodwork. It's not anybody that I would have known. It wasn't anybody that applied before. It's going to be a new entity, and what I'm going to need is to have the strongest base of endorsement from all the legislative districts that I can reach, somebody else I can reach out to. Hopefully, this is